Do I have this day an opinion, a personal opinion, on the outcome in Roe versus Wade? And my answer to you is that I do not.
But do you think there is as fundamental a concern as legitimacy of the court would be involved if Roe were to be overturned?
Well, Mr. Chairman, I think that the legitimacy of the court would be undermined in any case if the court made a decision based on its perception of public opinion.
I will decide every case based on the record, according to the rule of law, without fear or favor, to the best of my ability. And I will remember that it's my job to call balls and strikes and not to pitch or bat.
So a good judge will consider it as precedent of the United States Supreme Court, worthy as treatment of precedent like any other.
Senator, I said that it's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis. And one of the important things to keep in mind about Roe v. Wade is that it has been reaffirmed many times over the past 45 years.
I think it is a very serious threat to the independence and integrity of the courts to politicize them. I think that is not a good development to regard the courts as simply an extension of the political process. That's not what they are.
As Richard Fallon from Harvard said, Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled. It just means that it doesn't fall on the small handful of cases like Marbury versus Madison and Brown versus the board that no one questions anymore.
I think the most important thing for the public to understand is that we're not a political branch of government. They don't elect us. If they don't like what we're doing, it's more or less just too bad, other than impeachment, which has never happened, or conviction on impeachment has never happened with the court.
Two dynamics are fundamentally reshaping the structure and functioning of the American government. The first, which is quite well known, is Congress's decline. The second, perhaps somewhat less appreciated but no less significant, is the Supreme Court's ascent, its expansion of its power into areas previously thought to be off limits. These dynamics share a root cause: the partisan polarization that has reshaped American politics over the past 4 decades. But the connection is deeper and more complex than that. Whereas polarization weakened Congress, it emboldened the court to dismantle laws and, in the process, undermine Congress's ability to make laws at all, reinforcing Congress's sclerosis. The citizens and commentators shouting from the sidelines that Congress must act, fix itself, and reclaim its intended role are not wrong, but they miss that the court has made doing so nearly impossible. The practical result is a Congress caught between paralysis and policing, mostly incapable of translating collective judgment into law, and, when it does manage to do so, vulnerable to having its most significant accomplishments, civil rights enforcement, voting protections, campaign finance reform, administrative authority, erased by judicial decree. The judiciary, long conceptualized as a check on legislative excesses, is now defined by its own excess against legislative change. In the name of protecting the balance of powers, the court is radically refashioning that balance, claiming for itself the final and exclusive authority not only which laws stand, but over who gets to say what the Constitution means. The modern court's campaign against Congress began in the late 20th century, amid rising partisanship and institutional upheaval. The Gingrich Revolution, ushered into Washington by the 1994 midterm election, reshaped Congress, accelerating party sorting into distant ideological camps and normalizing scorched earth tactics. The court was not immune to these forces. As inter-branch rivalry morphed into systemic partisan competition, a judiciary dominated by Republican appointees began consolidating its authority at Congress's expense. This turn against Congress reflected a less principled commitment to limited federal legislative power than in opposition to what Congress was doing through the New Deal and Great Society. At risk were congressional assertions of its own interpretation of the 14th Amendment and efforts to enforce that vision in civil rights laws, as well as regulation of interstate commerce. These were domains where conservative activists had long sought to roll policies back, yet lacked the public support to do so. Jurisprudence accomplished what democratic policies could not. In quick succession, the court began circumscribing Congress's ability to define rights and act on its own constitutional imagination. Even acts framed as judicial modesty mask great hubris. Consider the Affordable Care Act, the most important domestic law since Lyndon B. Johnson's Great Society. In 2012, Roberts joined the court's liberal justices to spare the law from wholesale demolition. The remaining conservatives voted to strike it down in full. Yet the Chief Justice's upholding opinion declared that Congress lacked authority under its spending power to enact the insidiously constructed Medicaid expansion. In doing so, the court gutted one of the ACA's most ambitious components, denying millions of poor Americans in red states inexpensive health care coverage. Most dramatically, the court has deconstructed the Voting Rights Act, the crown jewel of the civil rights movement. Meanwhile, a constellation of campaign finance decisions, such as Citizens United in 2010 and McCutcheon in 2014, and others less well known, dismantled Congress's two most significant efforts to regulate private money in public elections, eroding the safeguards that protect elections as conduits of public opinion. Campaign finance laws do more than regulate money in politics. They embody congressional judgments about the conditions necessary for democratic self-government and meaningful political opportunity. The Roberts Court has hollowed out these dynamic sources of congressional constitutionalism. Its voting rights and campaign finance decisions have weakened the electoral systems that make Congress responsive to the public. In dismantling this scaffolding, the court has left Congress more detached from its electorate, diminishing its claim and role as a representative authority.
Artificial person canon.
Right.
Now, I wrote down beside that, even though you didn't, Citizens United. That's another one that's created a storm.
Well, person isn't used in the First Amendment. I mean, Congress shall make no law abridging the freedom of speech.
But what is your, maybe you don't even want to touch this, but what is your, as a person, do you worry at all? I know you don't, well, as a person, do you worry at all that there's too much money in politics?
No, you know, I really don't. I forget what the figures are, but I think we spend less on our presidential campaigns each year when there's a presidential election than the country spends on cosmetics. I mean,
well, but what about that unusual amount of influence? About, you know, people are worried that the corporations now can buy.
I think this is a real conduit. If you believe that, we ought to go back to monarchy, that the people are such sheep that they just swallow whatever they see on television or read in the newspapers. No, the premise of democracy is that people are intelligent and can discern the true from the false, at least when as the campaign laws require, you know who is speaking. You can't speak anonymously. You have to say, identify the people that are.
But we don't know who's
speaking
in right now.